Hello, everyone. Thank you for joining us today, and welcome to our program entitled Navigating the CRISPR Patent Landscape and Business Impact. This is the first web conference in a series we've entitled Era-Defining Life Sciences Technologies. So before I turn the presentation over to our speakers, I'd like to go over a few housekeeping items with you. Today's program will last approximately 1 hour, followed by a short question and answer session if we do have time. We do encourage you to submit written questions during the program. Please type your question into the Q&A widget open on the left-hand side of your screen. We will respond to written questions at the end, time permitting, and if we are short on time, we will certainly follow up with you individually after the program regarding your question. The webcast console that you're looking at can be completely customized. You can resize or move any of the windows that are open, including maximizing the PowerPoint presentation on your screen. If you experience technical difficulties during the presentation, please visit the webcast help guide by clicking on the help button, and somebody will assist you in that regard. The PowerPoint presentation today will be available on our website at Foley.com within the next couple of days, if not today actually, or you can obtain a copy of the slides in the resource list widget. As a reminder, today's program is being recorded and will also be available on Foley's website shortly in the next few business days. Foley will apply for CLE credit after this web conference wherever applicable. And we do apologize, this was a late decision, so many of you were not able to actually enter your CLE state and bar number when you registered. If you will be requesting CLE today, please send that information via email to me. My name is Allison Jones, and my email address is ajones@foley.com. That's AJONES@foley.com. To be eligible for CLE, you will need to be logged into this On24 session for the entirety of the program today. And you will also be asked to answer a polling question towards the end of the program. Please note that certificates of attendance will be distributed to eligible participants via email approximately 8 weeks after the web conference. As a final note, for those seeking Kansas, New York, or New Jersey CLE credit, you are required to complete an attorney affirmation form in addition to answering the polling question during the program today. A 5-digit course code will be announced during the polling question. Please email that course code along with your completed attorney affirmation form to me, again, Allison Jones at ajones@foley.com immediately following the program. A copy of that form was included in your reminder email this morning, and you can also access a copy on the resource list widget here. And with that, I will now turn the program over to our speakers. Thanks so much, and Steve, if you're the first presenter, please take it away.
Well, thank you, Allison. This is Steve Mabius from Foley and Lardner. And first, I'd like to offer just a brief disclaimer on behalf of all 4 of the presenters today. The information we're presenting should not be taken as legal advice or a legal opinion. You shouldn't construe this as a recommendation regarding any particular course of action. And the views that each of us will be presenting today represent our own personal views and shouldn't be attributed to our employers or any of our employers' clients. And I'm joined today by Catherine Breedis from Stifel Nicolaus. Catherine is a managing director and senior analyst in the major pharmaceuticals and biotech group. She's previously worked in large pharma as well as having prior experience at Goldman Sachs and GE Capital. We also have Simon Elliott and T.R. Yan, who are both senior counsel here at Foley in our chemical and biotech group. And with that, we'll go ahead and go through our agenda today. We're hoping to cover the following topics, and we'll do our best to get to each of them, as well as hopefully have a little bit of time at the end for Q&A. We're going to start with a brief intro to CRISPR. We'll talk a little bit about the market and investor viewpoint on CRISPR, and then we'll move into the patent situation and review some of the early information about who is filing patents, what types of patents are being filed, where do we see the most activity, and what types of claim strategies are being used by people pursuing patent protection in this area. We'll briefly discuss the status of the CRISPR interference, and then we will conclude with a discussion of some of the strategies that may be helpful to address the overlapping patents and licensing issues and safe harbor and enforcement challenges associated with CRISPR. And with that, let me turn it over to Simon to address the intro to CRISPR.
Thanks, Steve. So CRISPR stands for Clustered Regularly Interspaced Short Palindromic Repeats, and that refers to small sections of RNA that are used to guide the CRISPR process. What happens is there's these guide RNAs that target a specific region for the Cas9 protein to cut, and once the Cas9 protein is cut, it can be, that piece of DNA can be rejoined to create a deletion, or it can cut and you can insert new DNA into that point. As a result, CRISPR is very useful. It's compared to other previous technologies, it's very fast and specific, and it seems to be quickly emerging as a powerful tool with many applications. So the question is going to be, who controls the tools and who controls the application? Now, this creates broad market opportunities. Are we on this? Yes. So firstly, as the R&D tool alone, those can be protected and monetized. We've seen that in other areas. They can also be used, CRISPR can be used to produce cells or organisms that can be used as tools for drug discovery. Further down, we can see cell therapy, there's already an NIH-approved clinical trial, so essentially using CRISPR to modify T cells to make them better at fighting cancer or for resistant to HIV. CRISPR can be used for gene therapy, and it can be used for genetic modification of any species. Bacteria, so you could use bacteria or yeast and get improved industrial fermentation. Crops, we've already seen a CRISPR-modified corn. Mushrooms, non-browning mushrooms, and they've already done modifications in some other animals. There is, of course, concerns about germline gene modifications, but that's another issue beyond today's talk. Already on the market, we have these CRISPR-edited mushrooms that were designed to resist browning. And the interesting thing from the sort of monetizing and the regulatory perspective is it got approved very fast. And the reason it did is because it contained no foreign DNA. Therefore, it's not classified as a genetically modified organism, and therefore it does not go through the same degree of regulatory review. So they introduced this, but the question is it market acceptable? And it appears that, yes, they made this, but there was somewhat of a public complaint that they didn't want to have this frankenfood. So I think this demonstrates the challenges and promises of CRISPR, that maybe, at least in the near term, there's going to be a targeting to audiences and markets that are not averse to GMO. We already know that farmers are quite happy to adopt genetically modified corn because of its improved yields. And just briefly, we have the first proposed CRISPR human trial was announced this week. And the objective here is to use CRISPR to remove some receptors in T cells targeting the NY-ESO1. This is expected to make the T cells more persistent. It is based on some technology that was tried with other gene editing tools, but now they're really trying to see whether CRISPR is safe for use in people. rather than whether the CRISPR effectively treats the cancer or not. So it was approved this week by the NIH Advisory Committee, and it's being done at UPenn's Sean Parker Institute, and we look forward to the results of that. And with that, I'll turn it over to Steve Mabius.
Thanks, Simon. Next, we just wanted to give a few examples of some of the investors and some of the companies that are forming in the CRISPR area. And this is not an exhaustive list by any means of who the investors are or which collaborations have been formed, but it's just to give a flavor of some of the publicly announced investments in the CRISPR area. The three companies we have in this slide are CRISPR Therapeutics, Editas, and Intellia. You'll hear more about them during the presentation, but you can see here that there's a very diverse group of investors and certainly a lot of commercial interest in the CRISPR space. And with that brief intro to the investment side, I'd like to turn it over to Catherine, who's going to handle this next slide. Catherine?
Thank you, Steve, and thank you to the Foley and Lardner team for inviting me to participate in this exciting and timely discussion about CRISPR-Cas9. Well, as we've heard broadly in the media and from the top biotech companies in the CRISPR-Cas9 space, this technology has the potential for therapeutic applications across a broad range of diseases. In terms of the pipeline priorities of the top three CRISPR-Cas9 biotechs, these disease areas include, for example, genetic retinal diseases such as Leber congenital amaurosis 10 or LCA10, which is being pursued by Editas as their lead program. Non-malignant hematologic diseases such as sickle cell disease and hemophilia, as well as beta thalassemia, which are all areas of priority interest for Editas and CRISPR. Musculoskeletal diseases such as Duchenne muscular dystrophy, which is being pursued by Editas and I believe others. Genetic diseases of the lungs such as cystic fibrosis, which is being pursued by CRISPR Therapeutics in collaboration with Vertex as well as also Editas. And diseases that can be targeted broadly via the liver, such as alpha-1 antitrypsin deficiency or AATD, which is being evaluated by Editas and Intellia. Transthyretin amyloidosis, or ATTR, which is being pursued by Intellia in collaboration with Regeneron, hepatitis B, and certain inborn errors of metabolism, which are both being pursued by Intellia. And as well, oncology, as we've heard, with the first program, an academic program at UPenn, which is a TCR program that Simon described, targeting multiple myeloma, melanoma, and sarcoma. Next year, we know that Editas has plans to start their phase 1 with their lead program targeting LCA10, as I mentioned. CRISPR Therapeutics has stated that they plan to advance 2 programs into the clinic by late 2011, early 2018. And Intellia has announced that their partner Novartis plans to file an IND related to an ex vivo program in hematopoietic stem cells, or HSCs, in 2018. And in addition, they plan to start IND-enabling studies over the next 12 to 24 months for 1 to 2 programs which will deploy a lipid nanoparticle delivery technology and most likely target disease areas including ATTR, AATD, and hepatitis B. So in terms of the question, how is CRISPR-Cas9 perceived to be transformational? It really seems to span across a broad array. And again, these are very early days. To date, we have seen no clinical data, but the reported experience of major pharma and biotech companies utilizing CRISPR-Cas9 are noteworthy, particularly with respect to efficiency, enhanced cycle time, and we've seen that specifically in areas such as target validation, lead optimization, and even generating better animal models more quickly than traditional breeding methods. In terms of your question about in vivo therapies, again, we see a broad potential to address a broad array of diseases, particularly genetic mutations with high unmet medical need, and again, a broad spectrum of drug delivery strategies such as nanoparticles, AAV vectors, etc. In terms of ex vivo applications, likewise, I think there are a broad range of diseases, as we talked about. Cancer, in particular, via TCRs and CARs, is a likely strategy that is gaining traction both with Editas in collaboration with their partner Juno and Intellia in collaboration with their partner Novartis. We're also seeing, again, ex vivo applications through HSCs that could address non-malignant hematologic diseases. So again, lots to be seen, but still very early days. In terms of the last question, we've had 2 companies to date go public, as Steve mentioned earlier. These include Editas, which was actually the first IPO to price in 2016 on February 3rd. To date, and I would note, today is a very sporty day in the market, but to date, the shares have demonstrated approximately 56% upside to their pricing at $16 a share. With respect to Intellia, we've seen likewise relatively strong performance versus the market. They priced on May 5th, and the shares are up approximately 20% relative to where they priced at $18 a share. And I would mention in comparison to the BTK index, which is down 22% year-to-date, and IBB ETF, which is down 26% year-to-date, both of these companies have outperformed the market. And with that, I guess I will turn it back over to Steve for the continued dialogue.
Thanks so much, Catherine, and we're really fortunate to have Catherine's insights, given that it's such a chaotic day in the market, so thanks again. Next, we're going to move into a discussion of the patent situation. And what I'd first like to do is just point out the obvious, that patent applications generally do not publish for a period of at least 18 months. So we're dealing with untold numbers of unpublished patent applications in the CRISPR area. So that's important to keep in mind as we go through these slides. But it also highlights the importance of patent monitoring programs in an area where there's intense new patent activity. Setting up patent watches or regular monitoring can be really valuable for any company who's interested in this area. For one thing, it may enable you to get new ideas for drafting dominant claims that cover new parties who have filed after you have. It may also allow you to identify new cross-licensing or patent grouping opportunities to try to create a more valuable portfolio. And obviously, it's important to track multiple jurisdictions because there are people who are filing first in other countries, and their applications will not necessarily publish in the U.S. So next, just to illustrate what you can do in the monitoring of published U.S. patent applications, we did a couple of quick searches just by combining keywords and requiring their presence in the claims of published U.S. patent applications. And you can see that there were 7 published applications so far with the words CRISPR and maize in the claim, another 7 with CRISPR plus cancer in the claim, and 2 so far with CRISPR and truncated pancreas word in the claim. And this next slide is a little hard to see, but it just lists the 7 published applications with the keywords CRISPR and maize in the claims. And this next slide shows the 7 publications with CRISPR and cancer in the claims. And then lastly, the 2 with CRISPR and pancreas in the claims. And these types of monitoring efforts, you can drill down into each application and take a look at what's happening in the current prosecution which may give further insights into prosecution strategy and particular examiners who are handling these cases and what types of arguments are proving to be effective when dealing with examiners in each of these specific areas. And at this point, I'd like to turn it over to TR to talk a little bit more about the patent statistics in CRISPR. So, TR?
Thanks, Steve. So I want to give the audience an overview of the CRISPR-Cas9 patents that's been filed so far, including who filed the most patents and who are the top inventors that are named in these patents and patent publications, and as well as a brief introduction of some of the first-generation CRISPR patent applications that have been filed. This slide, the first slide, shows a year-by-year comparison of the number of CRISPR-Cas9 patents and patent publications over the last few years. And we obtained this number by searching the USPTO database for any patents or published patent applications that recite the word CRISPR or Cas9 either in the title, in the abstract, or in the claims. As we can see from this figure, up to the end of 2013, there are less than 20 patents and published patent applications that recite CRISPR or Cas9 either in the title, in the abstract, or in the claims. This number increased to over 60 for published patent applications in 2014, and the number further doubled in 2015. And in this year, the number of published patent applications are projected to increase to more than 150. So it shows that CRISPR-Cas9 is a fast-developing area in terms of patent filings. The next slide shows basically who filed these granted U.S. patents. As of May 19 of this year, there are a total of 32 granted U.S. patents that recite CRISPR or Cas9 in the claims, and among these, over 75% are filed by universities and research institutions, with the rest filed by companies, and none of the granted U.S. patents are filed by individual inventors. The next slide shows the number of published patent applications that have been filed as of May 19 of 2016. There have been 131 published U.S. patent applications that have been filed by universities and research institutions as of May 19, and another 125 have been filed by companies, and individual inventors have filed 8 U.S. patent applications that have been published that recite CRISPR or Cas9. The next slide shows basically the top university and research institution filers. As of now, it appears that Harvard University and Broad Institute have filed the most published U.S. patent applications, with University of California and University of Vienna jointly filed about 8 published U.S. applications. The other top university filers include Massachusetts General Hospital, Rockefeller University, Vilnius University in Lithuania, Stanford University, University of Washington, University of Minnesota, and University of Georgia. I want to make a note here that the number of patents or patent applications does not tell the entire story, obviously, because it is the quality and the scope of the granted patent that matters most. And in this regard, there is an ongoing patent interference between the Broad Institute and the University of California and University of Vienna patent portfolio, and which will be discussed later in this webinar. So the next slide is an overview of some of the top corporate filers. As of May 19, the companies, the corporate filers, the top corporate filers include Caribou, Regeneron, Agilent, Sangamo, Dow Chemical, DuPont, Recombinetics, Lectis, Sigma Aldrich, Turgeon, and Danisco. We note that the three human therapeutic companies that are of most interest to investors, including Editas, CRISPR Therapeutics, and Intellia, are not currently in this list because the published U.S. applications filed by these companies as of May 19 are of a relatively low number. This does not mean that these companies have not filed a large number of U.S. patent applications. It may just mean that these patent applications have not been published yet, as it takes 18 months for a new U.S. patent application to publish. So in terms of the top inventors who have been named in these CRISPR-Cas9 patents and published U.S. applications, they include Feng Zhang at Broad Institute, David Liu of Harvard, George Church at Harvard, Jennifer Doudna at Berkeley, Emmanuel Charpentier at Max Planck Institute, as well as Luciano Marafini at Rockefeller University. So the next slide provides an overview of some of the earlier generation CRISPR-Cas9 patents and published applications. These include the patent portfolio that have been filed by the Broad Institute, the patent applications that have been filed by jointly by University of California, University of Vienna, and Dr. Charpentier. And we denote this patent portfolio as the Doudna-Charpentier patent applications, as well as the patent applications filed by Turgeon, which is the company in South Korea. Lastly, there is a early CRISPR-Cas9 patent family, which is filed by Vilnius University in Lithuania. And among these four patent families, we know that there is a current interference between the Broad Institute patents and the Doudna-Charpentier patent applications. In addition, in two of the patent applications filed by Turgeon, on April 13, 2015, Turgeon has explicitly suggested for interference against the Broad Institute patent. As of today, the U.S. Patent Office has not taken any action with respect to Turgeon's suggestion. Lastly, for the Vilnius University patent applications, on June 9, 2016, one of the applications filed by Vilnius University, which is U.S. application number 14385241, has been acknowledged by the U.S. Patent Office to be allowable. However, the U.S. Patent Office forwarded this application to the Patent Board for a potential interference. Right now, we don't have any additional public information regarding what this potential interference is about, or whether this interference could relate to the ongoing dispute between the Broad Institute and the Doudna-Charpentier patent applications. However, we want to note that in the U.S., it is possible to have a patent interference of more than two parties. So, it has to be monitored of, how the Patent Board decide about this potential interference with respect to the Vilnius University patent application. So I now turn to my colleague Simon Elliott to discuss in more detail about patent interference.
Thank you, Tia. Just a brief note. There are some people who've been emailing me saying they're having problems with synchronization, and the IT people say if you press F5, that should help. So good luck with that. So for those who don't know what an interference is, it is something unique to the US, and it's really a patent office trial to determine who invented something first. And there is a very highly covered interference right now between Doudna at UC and Zhang's patent applications at Broad. And we're just given this little chart which shows the timeline. And you can see that at the top, Doudna has filed her first application in May 2012 and then continued to update with new material all the way until the non-provisional was filed in March 15th, 2013. Zhang filed his first application in December 12th, 2012, and then updated continuously until he filed his last application on October the 10th, 2013. This creates, and so as you can see, there's been continual updating of various applications information, and the question when you ask who invented first, you can see there is different amounts of new information that is being put in through the timeline. So we have the interference. 1 second. And the senior party is University of California because they filed first. The junior party is Broad. They have a whole bunch of patents and more to come. The scope of the interference, the count, as it's known currently, is essentially trying to see who invented this claim, a hypothetical claim. I've underlined the point eukaryotic cell because this is an important point. Who invented the eukaryotic cell aspect of CRISPR? And I'll just move this on. So the parties are disputing the scope. As I said, before deciding who is first to defend, the PTO must decide what the dispute is over. So University of California has argued that the count should not include eukaryotes. Broad has responded that even if it doesn't include eukaryotes, they were first. So this is an issue that's going to be decided backwards and forwards. UC also disagrees on whether an interference is possible because they asserted that Broad's filing strategy was under the AAA and so therefore cannot participate in interference. There's also another motion that was filed. So essentially the process will be a number of preliminary motions that are ongoing and should result in a November 17th hearing. And if that's not dispositive, then we'll go into a priority phase, which will last some time. With that, I'm just going to switch over to my colleague Steve Mabius, talking about how this relates to other past interferences.
Thanks, Simon. We just selected one previous biotech interference to provide kind of an illustrative timeline of events, and there's obviously a lot of differences here. The timeline we selected is from an HPV vaccine patent interference that took place a number of years ago. There were more than 2 parties involved in that interference, and obviously different technology. But the point we wanted to make is that there were a number of complexities involved here with this HPV vaccine. There were various licenses and research institutes involved, as well as commercial players and large pharma working to develop products while the interference unfolded. So in that sense, there may be some broader parallels that could be drawn. Eventually, what happened is the PTO declared a number of interferences in this dispute, but the parties had already entered into various agreements prior to a decision, and that illustrates one potential outcome of an interference is the fact that the parties may choose to settle pending the outcome of an interference. In other words, they agree to license each other regardless of who ultimately prevails in the interference. Another option is that they may settle an interference and terminate the interference so that the interference never reaches a final decision. So, in this case, the interference started 10 years after the first filed application. The issues were not ultimately settled as far as the interference goes until 6 years later, and that particular dispute involved an appeal to the Federal Circuit following the interference proceeding in the Patent Office. So you can see that it may take time to resolve an interference, but the parties may nevertheless reach certain levels of settlement or agreement even before the interference is completed. And with that, I'd like to turn it back over to my colleague TR to talk a little bit about publicly announced licenses in the CRISPR area.
Thanks, Steve. So this slide and the next few slides basically provide an overview of the licensing landscape of some of the early CRISPR-Cas9 patents. And in this slide, you can see that there are several companies that hold broad licensing rights to the early generation CRISPR-Cas9 patents or published or patent applications, including Editas, which has licensing rights derived from the Broad Institute patent, as well as CRISPR Therapeutics, ERS Genomics, Caribou Bioscience, and Intellia Therapeutics, which all have certain licensing rights derived from the Doudna Charpentier patent applications, which I will discuss in more detail in the next few slides. And in addition, DuPont also have an exclusive license from Venus University, and DuPont also have a cross-licensing agreement with Caribou Bioscience, which makes sense because the targeted market of DuPont and Caribou does not appear to overlap. So this slide provides a relatively straightforward landscape of which relates to the Broad Institute patent. The owner of the Broad Institute patent is the Broad Institute together with MIT and Harvard, and they have exclusively licensed this patent portfolio to Editas Medicine. And in addition, Editas Medicine also have licensed a number of patents and patent applications from Mass General Hospital and Duke University. Juno Therapeutics also have an exclusive collaboration with Editas in engineering T cells using CRISPR technology, including T cells with chimeric antigen receptors and T cell receptors. With respect to the Doudna Charpentier patent application, the ownership structure is a little bit more complicated than a typical patent. Here, there are three parties that jointly filed the Doudna Charpentier patent application, including University of California, University of Vienna, as well as Dr. Charpentier herself, who does not appear under an obligation to assign her rights to either University of California or University of Vienna. And for the rights that are held by University of California and the University of Vienna, they have been exclusively licensed to Caribou Bioscience. And Caribou Bioscience then granted an exclusive sublicense in livestock applications to Genus PLC, and also an exclusive sublicense in human therapeutics to Intellia Therapeutics. On the other hand, for the patent rights that derives from Dr. Charpentier, she has licensed exclusively in the human therapeutic field to CRISPR Therapeutics. And in non-therapeutic field, he has licensed her rights to ERS Genomics. And in addition, some of the second or further level licensees of patent rights that derived from the Doudna-Charpentier patent applications, including Novartis, Regeneron, Bayer, and Vertex. The next slide shows the licensing landscape relating to the Venus University patent applications. And it has been exclusively licensed to DuPont, and DuPont has cross-licensed with Caribou Bioscience. Next, I want to give the audience a brief introduction of some of the claims that we have seen in Cas9 patents and patent applications. Some of the most common claimed subject matter include method of using CRISPR, compositions and components of CRISPR systems, as well as genetically engineered cells and organisms obtained by CRISPR. And for the first category, it includes such subject matter such as methods for genomic editing in eukaryotic cells, methods for cleaving a target DNA, method for inserting a replacement DNA for homologous recombination, a method for activating or repressing target DNA transcription using mutated Cas9, as well as method for treating a disease by correcting certain mutations. And the claims that relate to compositions and components of CRISPR include mutated Cas9 protein, Cas9 fusion protein, such as Cas9 fork1 fusion, Cas9 guide RNA complex assembled in vitro, which is the subject matter of the current claims of the Venus University patent applications, as well as single guide RNA system comprising Cas9 and guide RNA vectors and the switchbird CRISPR systems. This slide basically gives an example of some of the patent prosecution issues that have been occurring in some of the CRISPR-Cas9 patent applications. In some certain, first of all, there is a patent eligibility question. In the U.S., for example, product of nature is not patentable. So if someone wants to patent the Cas9 protein itself, it's not possible right now in the U.S. You have to either mutate the Cas9 protein or have a fusion protein, somehow modify it for it to be patent eligible. And also there are certain subject matter that are difficult to claim in different jurisdictions, including human treatment, which is likely difficult to directly claim in Europe, as well as cloned animals, DNA sequences, and natural processes. Also, another question in prosecution of these CRISPR patent applications is whether a patent on a basic invention can reach through to a valuable end product. And this may depend on the quality and number of examples. And often you have to balance between the obligation or the desire to file as soon as possible, because right now we are under a first to file system. And on the other hand, the number of examples and experimental proofs that you have to generate. Also, just as any other patent field, in CRISPR-Cas9, prior art rejections are the most common rejections. And typically, the most cited prior art are the first generation CRISPR patent filings. For example, in the first patent that are obtained by the Broad Institute, the Doudna-Charpentier patent application was cited as a prior art based on an earlier priority date. And in prosecution, Broad Institute used a so-called 131 declaration to antedate the earlier filing date, the earlier priority date of the Charpentier patent application, and succeeded in obtaining a granted U.S. patent. However, as we all know, the same issue is currently under review in a patent interference proceeding. And the last common issue that occurs in the prosecution of CRISPR patent applications is double patenting. Because of the overlapping claim scope of many patent applications in this field, double patenting is a recurring rejection. And in most cases, the patent filers would use a terminal disclaimer to overcome such double patenting rejection. But the risk of using a terminal disclaimer, of course, is that it would be risky down the road to split the ownership of two patent applications. Because if you have a terminal disclaimer between two patents or patent applications, and you split ownership, one of the patent applications could be unenforceable. With those being said, I now turn back to my colleague, Simon Elliott.
Thanks, TR. Just briefly wanted to mention some of the new CRISPR areas. TR has given a great review about all the work that's being done with the CRISPR-Cas9 system, but with any new technology, there's always going to be competing technologies. So the first one is, instead of using Cas9 CPF1, people are using other proteins to do the gene editing. The CRISPR system, which was first discovered in one bacteria, has been found in lots and lots of other bacteria. So there are a whole pile of other proteins that are available, and people are trying to claim those. And we've already seen this story in the early days of PCR, when Kerry Mullis showed you could do polymerase chain reaction with the Taq thermostable enzyme, and then people came up with other thermostable enzymes, and there was an argument about whether those were infringing on the PCR technology. The term PCR was trademarked. So we could see something similar with people using other Cas9-like enzymes to work around the existing patents. Of course, the patents that are existing on CRISPR try to cover more than just Cas9. So we shall see how that goes. Now, there are other systems that are like CRISPR, but actually use some different technologies or different mechanisms. There's one called the NG-AGO, which came out a few months ago. It's still early days, but if this is another system that could lead to a parallel system, I suppose like Betamax and VCR sort of technologies. Now, the investment issues. Investors will need to know how will these perform relative to CRISPR-Cas9. CRISPR-Cas9 already has sort of the first mover advantage. It will probably get some advantages given that it's going to have the first clinical trial. It may be approved by the FDA, etc. first. Will it emerge as a standard? These are issues to look into. And there's always going to be questions from an investment perspective of overlapping claim scope and improvements. When there's a foundational patent and someone makes an improvement, there's a question about to what extent one can practice without infringing the foundational work, who owns what, etc. Let's just move through. And so there's just some more new CRISPR areas. I mentioned that there's a specific CRISPR applications in human therapeutics. Catherine mentioned a few more that are ongoing outside the U.S. By the way, the reason we have focused on the U.S. is just because it is sort of where the hottest market for this right now. But of course, there is a lot of stuff going on outside the U.S. there are new species created by CRISPR. We already have the mushrooms we've discussed, and DuPont Pioneer has made a CRISPR-Cas9 edited waxy corn. One area that could be very interesting is use of gene drives, where you have CRISPR hooked to something that changes the, makes a mosquito, for example, resistant to catching malaria or other diseases like Zika. And with a gene drive, once there's mating between the species, an organism that contains the gene drive will, all the offspring will be have their genomes edited so that they no longer can transmit malaria. So it's a dominant mutation, and it could be very powerful. Now there's people saying, well, we should try this for malaria and for Zika, etc. But of course, there are also people who are opposed to that. And there are, of course, lots of business issues. And with that, I'll forward over to my colleague, Steve Mabius.
Thank you, Simon. So we wanted to talk a little bit about licensing approaches that may be relevant and that probably have already been illustrated by the intense flurry of licensing that TR illustrated in his slides earlier. And some commentators have pointed to Cohen-Boyer as a model of the original genetic engineering patent from a long time ago, which was basically a low-cost license model. It was widely licensed on a non-exclusive basis, and it was similar in the sense that Stanford was dealing with an invention where the end products had not been clearly determined and had never been previously marketed. So it was a similar type of transformative technology. On the other hand, I think when we look at CRISPR, we see that the ability to bring product to market is happening more quickly, and there's more intense commercial activity right at the beginning. Whereas with Cohen-Boyer, there was a pretty long period of research-type licenses that were able to occur before commercialization really began. So there are some differences there. And I've also seen commentators express a fear that CRISPR will be owned by a single entity, but I think the earlier slides have demonstrated that so far there are quite a number of collaborations and licenses already granted, as well as a diverse array of research programs that are focusing on new products. And of course, the one CRISPR mushroom that's already on the market. Another possible analogy would be to the antibody area, where we saw that there were a lot of initially overlapping patents on underlying antibody engineering methods, but over time, a lot of situations were able to be resolved by cross-licensing, and today we do see many therapeutic products on the market, even though there were some initial disputes, and it took time for the licenses to be organized and rights bundled so that they could be made accessible to people coming into the field. So what do you do in the face of patent uncertainty and potentially overlapping patent claims? There are many standard licensing provisions that may be helpful. Anti-royalty stacking as a way of offsetting payments that may become necessary in the future for licenses to patents that aren't yet granted, that aren't owned by the initial licensor. Of course, there are contingent payments where you tie the payment of a royalty or some milestone to issuance of future patent claims. that cover an actually commercialized product. On the other hand, if your licensor doesn't want to agree to those kinds of provisions, you can try to request that the licensor indemnify you so that basically they pick up the tab if it becomes necessary to obtain future licenses to launch your product. So there's a variety of mechanisms available that could be deployed here. And lastly, I just wanted to mention narrow fields of use and research licenses versus commercial license. I think these approaches have already been utilized to an extent in the slides we saw earlier, which show a pretty diverse range of license relationships that already exist in the CRISPR space. In terms of anticipating enforcement challenges, I think this can be a useful exercise for people pursuing patent protection in order to brainstorm about the best types of claims to guard against future challenges. And so one of the questions is the extent to which CRISPR can be detected in an end product. Does it leave some sort of fingerprint? Does it require certain types of flanking sequences that remain in the end product that can be a basis for detecting whether a certain party has utilized CRISPR to get to that end product? Of course, we have research use exemptions in other countries. And in the U.S., we have a limited safe harbor under Section 271E for certain kinds of activity that relate to FDA approval that are pre-commercialization activities. And those may impact the way that people try to claim their inventions in order to capture as much infringing activity as possible, depending on what jurisdiction they're operating in or pursuing patent rights in. And the last one I just want to mention is the Bayer v. Housekeeping case, where a U.S. court held that importing information, such as a chemical structure, obtained by a screening method when the steps of the screening method were patented under a U.S. patent but not in a certain country outside the U.S., it turned out that that law wasn't useful for blocking importation of the information. It wasn't considered to be a product of a process patented in the U.S. because the word product was interpreted not to cover data or information. And some people view this as a loophole or a problem in the U.S. law, but it's just important that people keep it in mind as a potential area where maybe there are other ways they can craft their patent strategy to try to guard against this and be in a position to maximize the return on their patents. And with that, let me turn it over to Allison, who will talk briefly about CLE credit for today.
Thank you, Steve. So at this time, I'm going to read aloud the CLE course code for the program. If you are in need of CLE today for the presentation, please enter the 5-digit code that I'm about to read into the polling question on your screen after it's announced. Please be sure to press the submit button once you do enter the code so that we can track your answers. If for some reason you are not able to see the polling question on your screen, feel free to submit the code just via the Q&A box as well. The course code will be read only twice. It's a combination of letters and numbers, so please pay close attention. And we'll leave the polling question open briefly for a minute or so to allow you time to submit your answer. As a reminder, if you're in Kansas, New York, or New Jersey seeking CLE credit, on top of the polling question I'm about to read, we also need you to complete the attorney affirmation form and return it to me following the program. And again, a copy of that form was included in your reminder email this morning, and it's also available in the resource list widget. So right now I'll read the course code. The code is the letter Y as in young, the numbers 4, 0, the letter G as in George, and the number 8. Once again, that code is the letter Y as in young, the numbers 4, 0, the letter G as in George, and the number 8. Please enter the code now in the polling question or in the Q&A box if you are unable to see the polling question. We'll leave that open for a minute before moving on to the conclusions. Okay, at this time we're going to go ahead and close the poll, and I will return the program back to Steve. Thanks so much.
Thanks, Allison. Well, we're already at the end of the hour, and I'd like to offer a few wrap-up comments. And we've seen that there are some product areas where we have a quick path to commercialization in the ag biotech area with the CRISPR mushroom. In terms of patent claiming strategy, we need to try to think about who is performing various steps, how components and intermediates are used, the ultimate commercial end products. And at least initially, there are a lot of method claims that are being targeted, methods of editing DNA and producing different types of cells and organisms based on that editing. And as we move into second and third generation applications, we're likely to see more of a focus on methods of treatment, and potentially product by process claims may be helpful where the product has at least one difference over the prior art based on the steps of CRISPR editing used to make it. It may be a good way to get product types of claims granted, and those would hopefully not run afoul of product of nature eligibility issues to the extent they have at least one genetic difference from natural product. We talked about the balance between filing early but taking the time to get good data and identifying end products and fleshing out a patent application before it's filed. This is never an easy balance, and it's certainly going to be a challenge in the CRISPR area. And the importance of monitoring competitor applications, I think, is a critical takeaway because things are changing so quickly in this field, and there's such intense activity in filing. And lastly, the creative licensing strategies, which have already been illustrated by a number of the relationships in the earlier slides. I think people will need to continue to look for approaches and using all the various tools in the toolbox for addressing the uncertainty that exists right now and the potential of overlapping patent claims. So anti-stacking royalty provisions and cross-licensing and grouping of patents together to cover one field of use will continue to be important strategies. And with that, I'd like to thank everybody from joining. I believe that most of the questions that have been entered in the chat box have already been answered by my other presenters today. And to the extent you do have remaining questions, please feel free to contact any of us, and we'll do our best to provide answers offline. So once again, thank you to my fellow speakers, and thanks to all of you for joining us today.